Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. It is Wednesday, March 20th, 2 p.m. here in conference room 325, and we're also running this this committee hearing by video conference. Thank you to everyone for being here, and thank you for the speaker for stopping by, just checking in on us. Yeah, right. Are we in trouble? No, I guess not. We're okay. I wanted to ask those who are testifying, please limit your testimony to 2 minutes, and then at that point I'll ask you to summarize. If you're testifying by Zoom, please mute yourself and keep your video off until you testify, and then after your testimony is done, then we want to, if you could mute yourself and turn your video off at that point. If you have technical issues, use the Zoom chat function. And if you're disconnected, don't panic. Just join up again as soon as you can, and I'll try to fit you in and provide your testimony at that time. In case the power goes off in this building here and we have a network failure and we have to reschedule the hearing or schedule a meeting for decision making, we will post appropriate notice. If you're testifying by Zoom, please do not use trademarked or copyrighted images because that kicks us off of YouTube and that's not good. Please conduct yourself with aloha. Please refrain from any profanity or uncivil behavior. It's okay to disagree, but let's not be disagreeable. Okay, let's go ahead and get started. You want me? Okay. First up, we have Senate Bill 2836, Senate Draft 2, House Draft 1, relating to Maui's permanent housing recovery. I will turn it over to the Vice Chair to begin the testimony.
Okay, beginning us off, we have Office of the Governor, State Disaster Recovery Coordinator, Luke Myers. Welcome. Please proceed.
Chair, Vice Chair, members of the committee, Luke Myers, State Disaster Recovery Care, also of the Gov. We stand on our written comments and are here for any questions. We do believe in the value of this potential body, but there have been a lot of efforts to the long-term housing recovery support function between the federal, state, and local governments that play a complement to this existing group. Thank you.
Thank you very much. Next up, we have Office of Planning and Sustainable Development. Providing support. Hawaii Housing Finance and Development Corporation. Dean Minakam, please.
Craig Uri, Executive Assistant at the Hawaii Housing Finance and Development Corporation. We'll stand on our written testimony and support.
Okay. Department of Hawaiian Homelands.
Aloha, Chair, Vice Chair, members of the committee, Oriana Leao with JHA. The department stands on its written testimony in support of this measure. As noted in our testimony, we already have a number of projects pursuant to Act 279 in the pipeline, and we understand the need for collaborative efforts for recovery for Lahaina. Mahalo.
Thank you very much. Let's see, we have Maui Chamber of Commerce in support, Maui Hotel and Lodging Association in support, and an individual offering comments. Is there anyone else who wishes to testify on Senate Bill 2836? If not, members, questions? Okay. We have 3 votes. We can pass anything we like. Okay, never mind. You can't hear. Okay, next up we have Senate Bill 3157. Relating to direct negotiation for public land leases. And first up, we have the State Department of Land and Natural Resources.
Good afternoon, Chair, Vice Chairs, members of the committee. Ian Hirokawa with DLNR. Just want to reiterate in our testimony and support that we do support the amendments in the that the House Water and Land Committee made in the HD1. We believe it addresses concerns that were previously raised in prior testimony, as well as allowing the department to address sort of the critical priorities that the bill is trying to achieve. So we just want to note that, again, we support the HD1 amendments. Thank you. And I'll be available for any questions.
Okay, thank you. Now, we also have Russell Suji listed from DLNR. Is he also testifying, or?
No, he's just backing me up.
Okay, okay, got it. Let's see. We have Council Member Susan Lee Loy offering comments. League of Women Voters in opposition. Benjamin Sadowski, Unite Here, Local 5, offering comments, and Glenn Kagamida, an individual in support. At this point, is there anyone else who's wishing to testify on Senate Bill 3157? Please step forward. If not, members, any questions? Okay. Zooming right through the agenda. Next up, we have Senate Bill 2475. Relating to education. And first up, we have, let's see, Department of Education, Keith Hayashi, welcome, Superintendent.
Hello, Chair, members of the committee. The department stands on our written testimony in support. Thank you.
Mr. Superintendent, I'm going to have to do this because Chair always asks people who testify to elaborate a little bit more
Yes.
on their testimony.
Sure, Vice Chair. Thank you very much for the opportunity. We definitely support this bill as it protects our students from those potential individuals that may put them in situations that cause harm for them. So definitely, we support this bill as it protects our students in our schools.
Thank you very much.
Thank you very much.
From the Attorney General's office?
Good afternoon, Vice Chair Takayama, members, and Horiuchi, Department of the Attorney General. As we set forth in our testimony, the department is suggesting that a mechanism be added for removing names from the registry. Our testimony has suggested language to that effect. Also, the department is recommending that the indemnification provisions of the bill be amended. Thank you. I'll be available for questions.
Okay, thank you very much. Executive Office on Early Learning.
Hi, Vice Chair and community committee members. I'm Yuko Arikawa Cross, Director of the Executive Office on Early Learning. We stand in support of this measure. We believe all children deserve a safe and nurturing environment, and this bill will streamline information about individuals who have perpetuated harm against children, making that information more accessible across schools and departments. Thank you.
Okay, thank you very much. Let's see, we have Hawaii Teacher Standards Board.
Good afternoon, Vice Chair, members of the committee. My name is Felicia Villalobos. I'm the Executive Director of the Hawaii Teacher Standards Board. HTSB is in support, testifying on behalf of the board. HTSB is in support of SB 2475 SD2 HD1. We submitted written testimony with a comment that we would like the word institutions further defined by adding the words public or private before the word institutions. This would help clarify the definition of an institution. Thank you for the opportunity to testify. I'm available for any questions.
Thank you very much. Let's see, we have written testimony from the Department of Human Services offering comments. I don't see them here. Kamehameha Schools, testimony in support. Punahou School in support, and Hawaii Association of Independent Schools in support. Anyone else here in the room wishing to testify on Senate Bill 2475 or on Zoom? Yes, please. Please step forward and identify yourself.
Aloha, Chair, Vice Chair. My name's Mike Latham. I'm the president of Punahou School and the chair of the governance committee of the Hawaii Association of Independent Schools. We want to express our strong support for this bill. We believe it addresses a very serious safety concern. By creating a registry, it will help stop perpetrators of abuse at Hawaii public, private, and charter schools from moving from one institution to another. It covers employees as well as volunteers, and the goal is to do so in a way that protects children and provides a balanced approach with due process. We believe that it does this at this point. The bill requires that schools conduct an investigation, declare a finding, give notice to a perpetrator, report the name of a perpetrator to the registry, and then consult with registries whenever hiring. They are not able to hire if a perpetrator's name is listed on the registry. The due process provisions are important, requiring an investigation, an appeals process. We also support the Attorney General's recommendation regarding a removal of a name in light of new evidence, and we think that's a reasonable step. We want to thank the superintendent for his collaboration and the AG's office and the Teacher Standards Board as well. Thank you for your consideration.
That's all the testifiers I believe we have. Let me turn it back over to Chair. We didn't pass anything.
Thank you, Vice Chair. Sorry I had to step out. When the speaker calls, we have to say yes and respond. Excuse me. That's all the testifiers. Anyone else wishing to testify on this measure, Senate Bill 2475, on Zoom or in the room? If not, questions, members? Any questions? I do have a question. Let me ask of Mr. Latham, Punaho. This measure requires reporting institutions before transmitting an employee's name and other information for inclusion on the registry to certify that the employee either waived the right to appeal or lost the appeal. This requirement, however, is not included on the certification requirements for private schools, public charter schools, or early learning programs. So I'm thinking that I might modify the language in the bill to make it clear that that also holds true for private schools. Are you okay with that?
Yeah, absolutely. I think that's probably an oversight, and it should be consistent.
Okay, all right. Thank you very much.
Yeah, thank you.
Superintendent Hayashi, if you could come on up briefly. Just asking you the same question. You've got to clear what you've got to do, but public charter schools, I know they're under the Charter Commission, but I just wanted your opinion on it since you've been involved. Are you okay with making the reporting requirements across the board, not just for public schools, but private schools, public charter schools, early learning programs?
I am, Chair. Thank you.
Okay, all right. Thank you very much. Thank you. Any other questions, members? If not, thank you very much to everybody. You okay? Okay? You're okay. So let's move on to the next measure. Senate Bill 2351, Senate Draft 2, House Draft 1, relating to workforce development. I'll read a portion of the description. This renames the Hawaii Workforce Development Council to the Hawaii Workforce Development Board, clarifies that the Workforce Development Board is administratively attached to the Department of Business, Economic Development, and Tourism, and requires the Workforce Development Board and local workforce development boards to develop written conflict of interest policies consistent with federal law and regulations, requires the governor to select the chairperson of the board from among the business representative board members, requires the Workforce Development Board to assist the governor in coordinating local workforce development boards to improve the workforce development system, and it goes on. I'll leave you to read the rest of it in interest of time. First up, we have testimony from the Attorney General on this measure.
Good afternoon, Chair Tarnas, members of the committee. My name is Dale Fujimoto. I'm a Deputy Attorney General at the Department of the Attorney General. The department provided written comments regarding the bill, which I'll summarize now. First, the bill places the Workforce Development Council within the Department of Business and Economic Development and Tourism, or DBED for short, but the bill does not address Section 202-5 Hawaii Revised Statute, which places the council, the Workforce Development Council, within the Department of Labor and Industrial Relations. So the department requests that the inconsistency be addressed by striking the language in Section 202-1, placing the board or the council within the Department of Business and Economic Development and Tourism, striking that language and specifying, clarifying that the council be placed within a single department within Section 202-5. In addition, there's a reference in the chapter title of 202, and that reference of the term council should be changed to board to be consistent. That concludes my testimony. I appreciate the opportunity to testify today. I'm also available for any comments.
If we have questions, we'll call you up.
Thank you.
Great, thank you very much. Next, we have testimony from the Department of Labor and Industrial Relations.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee, Bill Kunzman, DLIR. The department strongly opposes this measure as drafted, and we prefer the House vehicle, which is HB 2199. We believe this measure reflects a misunderstanding of the intent and purpose of the Workforce Innovation and Opportunity Act, which is targeted to serve those with barriers to employment, which is low-income youth and adults and dislocated workers. It is not intended to be workforce writ large. The federal law specifies that the State Workforce Development Board is to assist the governor in achieving the state's strategic and operational vision and goals for those target populations, low-income and dislocated worker. The law is not designed to have a volunteer, private sector-led state board responsible for complex federal oversight responsibilities carried out by experienced, knowledgeable civil service staff. Thank you.
Thank you, Mr. Kuntzman. Next, we have Department of Business, Economic Development, and Tourism. Deputy Director.
Good afternoon, Chair, Vice Chair, members of the committee. Dane Wicker, Deputy Director at DBED. We stand on our testimony offering comments. Available for questions.
As I always do in this committee, I ask you to highlight the main points of your testimony.
Sure. So if we do, if the legislature decides to transfer this over to DBED, we would be looking at resources as well as the structure of the current board as it stands. It is quite large. We're open to the discussion, as workforce development is one of the main pillars under DBED strategic framework right now. Thank you.
Okay, please stick around because I think there may be questions. Thank you. Next, we have testimony from Tuiana Scanlon, President IATSE 665. Please proceed.
Hello, Chair, Vice Chair, members of the committee. Tuiana Scanlon, President of IATSE Local 665 and International Trustee. We stand in our written testimony in strong support of this bill. We believe that the language contained therein is the strong language that we need to adequately address the state's workforce development needs. Not included in there, what I would also like to make reference to the Workforce Innovation and Opportunities Act on page 16 of the bill itself. I will upload the link to the chat. It is much larger, the scope of what a Workforce Development Board is supposed to be as an entity and the functions they're supposed to serve besides just as an advisory board. It is much lengthier than that. It includes also potentially hiring staff to carry out its functions involving members of both the private business community as well as labor, as well as appointees of state and county government. We believe that this language will greater serve the populace of Hawaii, and we are available for questions. Thank you.
Thank you very much. Next, we have Alan Hayashi. In support. Please. If you would, I'd love to have you come up to the podium and introduce yourself and tell us the highlights of your testimony. Everyone on TV land wants to see you, sir.
Thank you, Chair. Alan Hayashi. I'm the former Chair of Workforce Development Council and here today as an interested individual. And my testimony essentially supports this bill. I think that there's a better alignment between the Department of Business, Economic Development, and tourism because of their research capabilities, and also they have the ability to decide on which sectors are the most critical for our economy, and therein lies something that we need to be able to collaborate with them on, to emphasize training within those sectors to make it more robust and sustainable. So essentially, that's my testimony.
Thank you. I appreciate you taking the time to highlight your testimony.
Thank you.
Next person that said they want to testify is Leslie Wilkins on Zoom. Not present. That's all the testifiers that said they wanted to testify. Is there anyone else wishing to testify on Senate Bill 2351? Here on Zoom. Seeing none. Questions, members? I have a question for DBED first. I appreciate that you said if the legislature chooses to do this, that you would be looking at resources. Are you saying that you would need additional resources in order to take on this responsibility?
That is correct. We would need capacity. We did speak with DLIR. They have in-house staff, including ASO and an administrator, that supports the workforce.
Yes, so we don't use acronyms. in
Sorry,
this
Administrative Service Officer.
Thank you.
Plus, they have an administrator under Workforce Development Division that supports the Workforce Development Council, and that undertakes a lot of the administrative work day to day. If that does come over, DBED will need to look at what capacity it needs, plus looking at the 41-member council makeup right now, it looks a little large. We would have to dive in and understand what the federal requirements are to having those members on the board.
Okay. Let me ask a question. Now, here we have the legislature telling the administration that they need to reorganize, move a significant program from one department to another. You're saying if the legislature decides to, we'll need this. Has Department of Business, Economic Development, and Tourism met with Department of Labor and Industrial Relations and decided between the two of you where this program should be?
We have not discussed where it should be.
You haven't?
No. We've only supported, this came up in the prior committee.
I know, but there's been quite a while between the prior committee and now. So you haven't talked to decide between the two agencies where the Workforce Development Council should be from the administration's point of view?
No.
Okay. Thank you for letting me know that. Department of Labor and Industrial Relations, please. Oh, wait. Director Tokioka. Could you answer the question?
Thank you. The view is much different from this side of the room.
Welcome back. Welcome back.
So we had brief conversations, and so I did have a conversation that Deputy Director was not a part of. We weren't sure this question was going to be asked, but certainly as a brother-sister relationship with the Department of Labor, this is under their purview. And for everyone to know, this was not DBED's idea to take this initiative. So we want to make that very, very clear to our friends sitting over there. And as an administration, the Department of Labor, who is under right now, they want to keep it. We never wanted to take it. But if the legislature decides that that's what's going to happen, then we go back to what Deputy Director Wicker said, that we're going to need resources to do it. But we are not raising our hands saying, we want resources, we want to take this task on. And I can say clearly that Director Boutte and I had a conversation, and he made it clear to us that he feels that the council should remain with the Labor Department, and I did not argue with him.
Thank you. I appreciate that clarification. That's very helpful.
Yeah, thank you.
Thank you, Director. Department of Labor and Industrial Relations? Could you give us, well, I guess first thing is, would you prefer in whatever form, if this committee decides to move out this bill in one form or another, do you need to have included in here, or would it be helpful to include in here language that would add a program ID for Workforce Development Council?
It is not necessary. There is nothing in the federal law that requires that. It can operate the way it is currently, so no, we don't need that.
You don't need that, okay.
No.
Okay, thank you. And then could you please give us a synopsis, a summary of why the Workforce Development Council should remain where it is now? After you've heard the testimony from others, Mr. Hayashi, others who have testified, and others that you haven't testified but certainly have called me. Could you give us a summary as to why it should remain in DLIR, which is your position?
Well, I think as far as the subject matter goes, employment, workforce development, that's really in our wheelhouse as a department. That's our, that's our mission. And on top of that, we also have the expertise of having operated with the law this goes back to even previous, under the Workforce Investment Act of 1998, and the WIOA, or the Workforce Innovation and Opportunity Act, built on the WIOA. But a lot of the administrative requirements and the fiscal requirements and the audit responsibilities are very similar. So it's something that we have a long track record with. And we have both in-house staff in our Workforce Development Division as well as in our Administrative Services Office who have the knowledge and expertise to be able to help oversee these programs.
Okay, I've received texts from the person who's currently the executive director asking me to pass this bill. We've received testimony from a former executive director. Could you address some of their concerns, their comments, and give us a reason why it should stay in DLIR with the encouragement from those individuals who are in leadership roles at the Workforce Development Council to move it?
You know, the previous person who served on the council and other members who currently serve on the council have had a relatively short time with the program and the law. So I don't know if their level of understanding is the same as the department's. And so, yeah, I'll leave it at that.
Okay, so based on your better understanding, longer time period, your professional
Expertise
recommendation
is to keep it in labor, yeah.
Okay, thank you. Any other questions, members? If not, thank you for answering what I'm sure was an uncomfortable question, but thank you for answering that. We have to deal with uncomfortable issues in this committee. Okay, let's move on to the next measure. Senate Bill 578 relating to government. This allows a retirant to be employed without re-enrollment in the employee's retirement system and without loss or interruption of retirement benefits if the retirant is employed as an investigator in a position identified by the Department of the Attorney General as a labor shortage or difficult to fill position subject to certain conditions. And then it goes on. First up, we have testimony from the Attorney General. Welcome.
Good afternoon, Chair, members of the committee. My name is Stella Camp, Deputy Attorney General. The Attorney General is in strong support of this bill. It would allow the Attorney General to hire retirees for hard-to-fill AG investigator positions, and those retirees would not have to re-enroll in the employees' retirement system. I'm available for any questions.
Thank you. Next, we have Department of Law Enforcement. Deputy Director Vincent, welcome. Please proceed.
Chair Tarnas, members of the committee, the Department of Law Enforcement supports the bill. We would like to ask the committee to include the Department of Law Enforcement in the bill. We have the same problem that the Attorney General has with respect to filling these investigator positions. Investigators are typically paid, in our department, for example, they're paid less than our deputy sheriffs are. We had a bill to try and move them to BU 14 that died, but this is, finding criminal investigators to fill these positions is difficult. And when I was with the Attorney General's office, it was a perennial problem getting qualified people to come in and actually do the complex criminal investigations. We're going to have a serious problem filling these positions if this passes and we're not included. But we'd like to make sure that the Department of Law Enforcement is also included. We included some suggested language for the committee. Thank you.
Thank you very much. Hawaii Farm Bureau. Welcome.
Good afternoon, Chair, Vice Chair, members of the committee. Brian Miyamoto here on behalf of the Hawaii Farm Bureau. You have our written testimony and support. We are supporting this with comments. It may not make sense because this is addressing Attorney General. However, that's the current version. The previous version did include Department of Agriculture, and we are having some challenges at Department of Agriculture with certain hard-to-fill positions. So we are requesting, Chair, that the Department of Agriculture be added back in, as in the SD3. Again, same situation that you heard the Attorney General and Department of Law Enforcement. We have these positions. The Department of Agriculture is very complex, certain requirements, certain education and experience backgrounds, and we don't want to lose a pool of qualified individuals to serve in certain managerial positions. So we do request an amendment to add Department of Agriculture back into the measure. Thank you for the opportunity to provide testimony.
Thank you very much. We've also received testimony in writing and support from Eric Tanoe, Hawaii Floriculture and Nursery Association, and comments from Thomas Williams with the Employees Retirement System. Is there anyone else wishing to testify on Senate Bill 578? You're on Zoom. If not, questions, members? I have a question, Department of Law Enforcement. Sounds like this is a personnel hiring issue. What has Department of Human Resource and Development told you?
The problem is finding qualified individuals that will come in and do that.
With that problem, you must have talked to DHERD, the Department of Human Resource and Development.
Our CID chief told us this morning that he just got a list of, I think, 7 applicants for their positions. So there are some people on.
What's CID?
I'm sorry, Criminal Investigations Division.
Oh, thank you.
I'm sorry. Got a list from the Department of Human Resources Development recently, and it was 6 or 7 applicants that are on the list, but that's the total number on the list for the criminal investigations.
Well, you got 6. That's better than 0.
Well, we'll see how many of them get
I
hired.
wish you the best, and hopefully they're good applicants, and that'll move forward. But thank you for letting me know that you have been working with DHERD on this.
Yes, thank you.
Okay, thanks very much. Any other questions, members? If not, thank you very much to the testifiers. We're going to move on to the next measure. Senate Bill 2556 relating to the Community Outreach Court. This measure permanently establishes and appropriates funds for the Community Outreach Court as a division of the District Court of the First Circuit. First up, we have testimony from the judiciary. Welcome. Take your time.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. I'm Brooke Mamizuka, Social Services Manager and Probation Administrator. The judiciary strongly supports SB 2556, Senate Draft 2, House Draft 1. The judiciary respectfully requests that the effective date of July 1st, 2000 on page 9, section 11 of this bill be amended to take effect July 1st, 2024. The Community Outreach Court, it changes people's lives. It makes a difference with struggling individuals that bring their families that need help. They gain, when they leave, they gain self-esteem, they improve their living conditions, their family life, and overall the community. The Community Outreach Court resolves legal issues, but it does more than just that. It also links our clients directly with services. Last week, Friday, March 15th, we had a huge service fair. We invited over 35 service providers that came to help our clients. We helped probation, parole, and our community outreach court clients. We were able to service them with showers, haircuts, SNAP benefits, legal identification. We did a number of services that were so beneficial to our clients. But all of this takes a lot of manpower. And right now, I'm borrowing from programs. We're borrowing staff from other courtrooms in order to make the court operate. So we have bailiffs, we have court clerks, we have social workers that are all kind of chipping in, including the judges. Our funding is very low, and everyone does drives in order to keep this program going. So we do clothing drives, we do school supply drives in order to keep our community and our keiki all safe and healthy. So I'm asking you for your support for this bill, and I'm available for any questions.
Thank you very much. Next, we have testimony from the Office of the Public Defender. Welcome. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. Office of the Johnny Kanaga, Public Defender from the Office of the Public Defender. We support this bill. For the same reasons Ms. Mamizuka just talked about, this is a very important program. I would also like to highlight the fact that one of the biggest utilities of this program is that the court goes to these people. Oftentimes these people are homeless, lack transportation or licenses, which is one of the benefits of the program. They get their licenses back. And so having the courts go out in the community to these people is essential to getting these people to court. Also, as Ms. Mamizuka stated, the service providers other than the court go out to these to the court sessions and are able to hook up with the clients, provide other services. So I've had a client who actually not only got his license back and cleared his record, but also was able to get essential services through one of the service providers, even medical one time when he had an emergency. So this is an essential program and we support it. Thank you.
Thank you very much. Next, Department of Law Enforcement.
Good afternoon again. Department of Law Enforcement strongly supports this measure. It addresses a chunk of the community that is able to get help. This is one of those criminal justice reform that actually benefits everybody, not just the individual, but their family, the communities as a whole. Department of Law Enforcement strongly supports it. The appropriation amount that we are asking be included in there is so that we can always have a couple deputy sheriffs available to go with the program participants to actually provide security and support them as they go out into the community and do their work. Thank you very much.
Thank you very much. We received testimony also from the Statewide Office on Homelessness and Housing Solutions in support. Testimony from the Department of Human Services in support. Testimony from the Honolulu Department of the Prosecuting Attorney.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. I'm Paul Mao, Chief of Staff for the Department of the Prosecuting Attorney. I'm here in opposition, in part, to SB 2556 SD2 HD1. While the Department of the Prosecuting Attorney continues to support the Community Outreach Court, we ask that the committee focus on the following. One, the Public Defender's request to end their role as the pass-through agency for the Community Outreach Court. We support that. Two, we support expansion into other communities by increasing the funding of additional personnel for the Office of the Public Defender, the Judiciary, and the Department of the Prosecuting Attorney. SB 2556, however, creates a new chapter in the HRS for Community Outreach Court, which we feel is unnecessary, since the judiciary is already permitted to create and/or participate in specialty courts or projects that it chooses. Really, our main area of concern is about the repeal of Act 55. Act 55 was passed in 2017 and established the Community Outreach Court. And in doing so, it set the processes for the program. These are critical processes that were spelled out in Section 4 of Act 55, and unfortunately, they were not included in SB 2556. We feel that they are necessary to protect the community. The program under Act 55 allows for the disposition of cases only when the prosecuting attorney and the public defender have negotiated and reached a plea agreement on the disposition of the defendants. Agreement between the prosecuting attorney and the public defender, we feel, is essential to prevent admission of inappropriate defendants into the Community Outreach Court. I think we all can agree that these defendants must be nonviolent, charged with a non-felony, and appropriate for participation. Thank you for this opportunity to testify. I'm available for questions.
Thank you very much. We have testimony and support from Partners in Care, Oahu, Continuum of Care. We have testimony and support from the Hawaii Substance Abuse Coalition, and testimony and support from ACLU of Hawaii. That's all of testimony that we've received. Is there anyone else wishing to testify on Senate Bill 2556? If not, questions, members? Representative Ganadin, please proceed.
To the judiciary. Good afternoon. Congratulations on the success of this program. Does the judiciary have a response to the Office of the Prosecutor in Honolulu City and County's request to, I guess, reinsert language from Act 55? My experience from being a defense attorney is that prosecutors and public defenders rarely agree on much. And because of the system that we have in criminal justice, agreement is often not found, and you just go before the courts, and that's why the court system exists. I'm just wondering if the judiciary has a response.
Adding more language into the current bill, I don't see a problem with adding those specific things that the prosecutor is asking for, adding it into the bill.
Is the agreement regarding the defendants who are accepted into the program, or is it agreement regarding the disposition of the case? I'm trying to figure out what they're trying to discuss regarding agreement.
It's an agreement to the entry into the program.
All right, so you're okay with the language to reinsert the language from Act 55 from 2017?
Yes.
Also, in reading the bill, there isn't an appropriation for a judge. Am I getting that wrong?
No, there isn't an appropriation. There's no.
So judges just on their own accord are either assigned this community court duty or they just do it? How does that work?
Yes, they're assigned to the community outreach court.
Thank you.
Thank you.
Any other questions, members? If not, thank you very much. We'll move on. Senate Bill 2557 relating to legal representation. This measure allows a court to appoint an attorney for the subject of a petition for assisted community treatment if the interests of justice require one be appointed. Repeals paragraph 3 of section 802-1A Hawaii Revised Statutes, which entitles the subject of a petition for assisted community treatment to legal representation by a public defender. First up, we have testimony from the public defender.
Good afternoon, Chair Tarnas, Vice Chair Takayama, committee members. We support this bill, which it kind of clarifies the language which was removing a person who is referred for ACT hearing as an indigent person. So previous amendments to the statutory scheme had removed the Office of the Public Defender from representation at ACT hearings. So I think this was intentionally left in at some point for the outside possibility that there could be a situation where a subject of the ACT would need an attorney. So right now they get GALs.
GALs,
guardian ad litem. Yes, guardian ad litems. So we support this language. It does still allow for the court to appoint an attorney, not the public defender's office, in a situation where the subject may need an attorney. So we support this matter. Thank you.
Thank you very much, sir. Next, we have testimony with comments from the Hawaii Disability Rights Center. Mr. Urdachek.
Good afternoon, Chair Tarnas, committee members. I'm Lou Urdachek, Director of the Disability Rights Center. So this bill started out and is merely a housekeeping measure. I understand that. It basically cleans up the HRS to reflect the decision that the legislature made a few years ago. But I see it as an opportunity to revisit that issue on the one hand, and it also does open up a lot of other questions that are tied in with other measures that are going through this session. So it used to be when the ACT program first came into existence, everybody who was a respondent was represented by an attorney, and it was the public defender's office. And then somewhere along the line, people were frustrated. A lot of times you had, and understandably so, maybe you had mothers whose sons were mentally ill and they were trying to get them help, and they came to the legislature and they complained that these tricky, aggressive lawyers were somehow getting these cases dismissed on technicalities and the son wasn't getting treated. So the legislature then said, okay, well, we'll take out the public defender, and so we won't give them anybody to represent them. They substituted a guardian ad litem, which all the guardian ad litem does is advocate for the so-called best interest. They don't represent them as lawyers. Mind you, their best interest may very well be taking medication. I'm not arguing about that. But so the current law, under the current law, all they have is a GAL. So in the context of that alone, this bill is an improvement over the current law because it says, well, the judge can at least appoint an attorney if justice so requires. At the same time, as lawyers, we start thinking about all the implications of that. So are there criteria that the court would have to set up? Does the judge need to make a finding as to why they did appoint somebody or didn't, or would it be solely discretionary? So there's a lot of unanswered questions. The other thing is that if you don't look at this bill just in its own context, a few weeks ago, this committee heard House Bill 2159, which was advanced over and heard today. That bill brings the Attorney General in to represent the petitioner. So now you have a situation where not only does the respondent who used to get a public defender no longer have an attorney, but now that mother or whoever that petitioner is going to have the Attorney General and the full force of the entire state representing them against the person that has no attorney. So the limited research that I've done to date indicates that, I mean, I don't know any state, and a lot of states have ACT programs, I don't know any state that doesn't appoint attorneys as a matter of course. I cannot imagine that you're not treading into some very serious due process constitutional violations if you're, especially if you appoint the Attorney General to represent them and you don't give them the right to counsel. So this bill offers an opportunity to explore a variety of issues, and as I say, in its current form, it's better than the current law, but we really think that the legislature needs to seriously consider appointing counsel, and it doesn't have to be the public defender. A lot of other states just have court-appointed counsel, just like when you have two co-defendants and they both qualify for the public defender. There's a list of attorneys who do these cases, so it doesn't have to be them. So there's lots of options, and we're happy to help any way we can.
Thank you very much. Next, we have testimony in opposition from the ACLU of Hawaii.
Aloha Chair, Vice Chair, Committee members, Carrie Ann Shibota, Policy Director on behalf of the ACLU of Hawaii. We oppose this measure because in plain, simple language, it violates our Constitution. Individuals who have disabilities, whether mental health or co-occurring disorders, are still entitled to rights under our U.S. and state Constitution. This strips away their rights. I would like to point out again in some of the limited research I've done that in states such as New York, Kendra's Law, California, Laura's Law, which our bill is modeled after, they explicitly provide in their statutes that individuals subject to ACT petitions, assisted community treatment, in those states they call it assisted outpatient treatment, are entitled to legal counsel at every stage of these legal proceedings. It is a legal proceeding in the court of law. There is the imbalance of powers. And while, again, we understand that the guardian ad litem plays an important role, the best interests of the individual, their client, that is a different legal standard than representing and safeguarding people's due process rights. We, again, our position is to protect, advance the rights enshrined in our both state and federal constitution, and we kindly ask that you afford people their full rights and either, one, defer this measure, two, reinstate public defender, or three, as has been pointed out, just ensure that there's court-appointed counsel in all cases. It should not be discretionary. Just imagine in another context, if the court gets to decide which defendants get to have legal counsel or not. If a person is indigent, they should be entitled to legal counsel. Thank you, and I'll be here if you have any further questions.
Thank you very much. We've also received testimony in opposition from an individual. Is there anyone else wishing to testify on Senate Bill 2557? If not, questions, members? Question for the public defender.
Yes.
In your opinion, is the measure as it's written unconstitutional because it doesn't provide due process, by requiring an attorney for the indigent person?
Well, I believe the ACT statute is that it provides a measure of due process to persons who are subject to the ACT petition. So it's not, they have the right to a hearing and the GAL. Now, to the extent that that could be challenged, I guess at some point, that would be up to the courts whether the degree of due process that's afforded by the statute is sufficient. Up to this point, there have been ACT hearings without our office in it, after our office was removed. And I think that there was one case that I think triggered this particular push, and it was an instance where the GAL decided that due to concerns raised by the subject's mother, that the court should appoint an attorney. So the court had turned to our office and sought to appoint our office as counsel, and I think that's what kind of precipitated some of this. So,
what's your opinion about why, or what's your rationale for why the public defender should not be representing these individuals?
Well, so generally the public defender's office represents persons who are subject to incarceration or being, I guess, held against their will. So that would be like, for instance, in an IC hearing, involuntary civil commitment hearing, where the person is committed to a hospital involuntarily against their will, or persons who face jail. So for instance, we don't represent persons on violations, offenses that are not subject to jail time. The 8021 specified that a person who is subject to these hearings is indigent. Generally, we make a determination of indigency by having persons fill out an application. So they come to our office, they fill out an asset and debt statement, and we determine whether they qualify as indigent. So this, by defining a person per se who's subject to these proceedings as indigent, it bypasses that indigency determination. So technically, there could be a person who would not qualify normally as indigent, who would be afforded the public defender simply because the definition now includes persons subject to the ACT hearing.
So that's why you don't think public defenders should be representing these individuals?
Yes, I have no objection to the, to a court-appointed counsel being given to persons subject to these petitions. However, our office, as I said, generally we represent indigent persons who are subject to incarceration or commitment. So the inclusion of the ACT subjects was just a per se definition that was added so that we could come into the ACT hearings initially.
Okay, thank you. Any other questions, members? No? Representative Ganadin?
Yeah. I suppose, if not you, then who?
Well, there are there's a list of court-appointed counsel who are available to the court. So, the court can, on its own, appoint court-appointed counsel, and that wouldn't be necessarily have to be based on indigency. It could just be based on an amendment to the statute.
Thank you.
Thank you. Any other questions? If not, thank you very much. We'll move on. Thank you to the testifiers. Senate Bill 2685, Senate Draft 1, relating to abusive litigation. This measure establishes judicial procedures to prevent and remedy abusive litigation. First up, we have testimony from the judiciary. Welcome, Judge.
Afternoon, Chair Tarnas, members of the committee. I'm Jessie Hall, judge with the Family Court, and you'll see in our written testimony, we did ask for a few changes. We are not taking any position on the bill specifically, but with the changes that I did want to point out for you with regards to paragraph, I believe it's 2B, yes, 2B, we would suggest its removal. One of the main problems with that provision is it's a pending criminal charge, which means there has not been a finding that abuse has actually occurred. A charge to be brought, there is probable cause, but that's probable cause that the charge may be able to proceed forward, not that there's actual abuse. So we are concerned there'd be due process. It also does not take into consideration what would happen if the defendant is later than has the case dismissed or is acquitted. Will they still be part of this, held under part of this statute? The next change we are asking to be removed is paragraph 2I, which would allow for a signed affidavit from a domestic violence or sexual assault agency. Our problem with that is that it's hearsay and would be in violation of our rules of evidence. I'm assuming that the agency would not have direct knowledge of the events that occurred, and so it is a violation of the rules of evidence on that, and we do have concerns with that. The only other change I'd like to point out is we just ask that if it is passed, please give us some time to put in new forms as well as to allow for training. Thank you.
Thank you very much. Next up, we have testimony from the Hawaii State Coalition Against Domestic Violence.
Aloha Chair, Vice Chair, Committee members. It's Angie Mercado from the Hawaii State Coalition Against Domestic Violence, and we stand in strong support of SB 2685 SD1. We did respectfully recommend one amendment specifically to address the judiciary's concern about due process when there is somebody who is pending, who has been arrested and is pending conviction. So we added some language that we hope will address due process concern and will also address our concern that there may be some action taken by the courts that will take into consideration the safety for survivors. We do also agree to the recommended amendment by the judiciary to remove the affidavit from the program. As stated by the judiciary, if this is not going to be something that is accepted, we're concerned that this will also give false hope to survivors who may be seeking relief under this measure. I'm available for any questions you may have. Aloha.
Thank you very much. Next, we have testimony from Hawaii Children's Action Network Speaks. Ms. Wu.
Aloha, Chair. Aloha, Chair, Vice Chair, members of the committee. Nicole Wu, Hawaii Children's Action Network Speaks. Thank you for hearing this bill. We care about this bill because often domestic violence survivors with children are susceptible to abusive litigation because this often happens in the context of custody cases, child custody cases. And so we believe abusive litigation often re-traumatizes children and their families. So we urge you to join the other states that have enacted legislation to address abusive litigation. And thanks for hearing my testimony.
Thank you very much. Next, we have testimony and support from Parents and Children Together. Also, testimony and support from 2 individuals with the Domestic Violence Action Center. And testimony and support from an individual, Shana Wailana Kukila, not present. And then we've received testimony from 5 other individuals in support. Is there anyone else here wishing to testify on Senate Bill 2685? If not, questions, members? Representative Ganadin, question for Ms. Mercado.
Still there?
There she is. Please go ahead, Representative Ganadin.
Good afternoon. Many years ago, I used to be a staff attorney for the Domestic Violence Action Center. Does DVAC and other similarly situated nonprofits throughout the state, when they take a client on for a family law case, in the instance an opposing party wants to amend a custody order, is the person they took as a client, are they still a client? So will the agency still take this person if there's a new motion?
I actually don't know the answer to that. I think it would depend on, each agency's caseload and if they would have the capacity to be able to continue to work with that client. So I don't want, yes?
The reason I'm asking is, oftentimes, people's lives change. Parents or guardians, they move away, and people file non-frivolous motions to amend a custody order, and the court, for reasons totally within the law, decides to hear the case. So I guess once somebody is, ordinarily, once you take a client, they're your client. Throughout the duration of the case, these family law cases take many years to conclude sometimes. So DVAC is not going to continue taking these cases if somebody comes in with a new motion?
Unfortunately, somebody from DVAC is not here, so I can't speak on behalf of DVAC, but I think if please correct me if I'm wrong, but I think that you're also trying to address the fact that if circumstances change, are we going to, fight fight whether or not, or prevent them from being able to change custody orders? And definitely the intent of this measure is not to prevent anybody from their due process, from the ability to change custody as life circumstances change, but that if the survivor has an experience where this is something that is constantly being done, and there's a pattern to this, we want to be able to give them a place to be able to address this.
How many attorneys are specializing in this work statewide? If you have that information. The reason I'm asking is this was in the news recently that there were, I believe, 7 attorneys that were working with the Domestic Violence Action Center that decided to leave the agency. So there's some ongoing current concern about representation.
Sure, but also the news also reported that that agency has also outsourced to other family practice attorneys, and so there are going to be survivors who are going to be able to access, representation on their own. Not all survivors need to go through the domestic violence action centers. This would be under general family law practice. So we would think that anybody who is going to be able to do family law practice should be able to engage in this. There's always, as we always encourage attorneys to be doing the continuing education, but also we hope that those law firms that have specialties, any particular specialties in this, will offer their pro bono hours to our survivors of domestic violence.
Thank you.
Thank you. Any other questions, members? If not, thanks very much to the testifiers. We'll go on to the next measure, Senate Bill 2319, proposing an amendment to Article 6, Section 3 of the Hawaii State Constitution to increase the mandatory retirement age for state justices and judges. First up, we have the judiciary in support. Next, we have the Office of Public Defender in support. Next, we have Community Alliance on Prisons in support. Next, we have the Stonewall Caucus of the Democratic Party of Hawaii in support. And we received testimony and support from 3 other individuals. That's all the testimony we received. Is there anyone else wishing to testify on this measure? If not, no questions, no one to question. So we'll move on to the next measure. Senate Bill 3139, SD2 HD1, relating to crisis services. This measure establishes a crisis intervention and diversion services program within the Department of Health to expand existing services to divert those with mental health issues to appropriate healthcare services. Requires the Department of Law Enforcement to coordinate crisis intervention training for state and county law enforcement agencies and training and certification for crisis intervention officers. It defines mental health emergency worker and crisis intervention officer and appropriates funds. First up, we have the Office of the Public Defender in support. Next, we have Department of Law Enforcement.
Chair Tarnas, Vice Chair Takayama, members of the committee. Throughout the session, we've been dealing with a number of measures in this area, and this is one of those. And this actually right now is started out life as just the Department of Health component of it. And then there was the crisis intervention training, and so this bill actually represents the kind of the meshing of the two. There were things in both bills touching on the same sections of the law, and so this version actually meshes the two. And we are in strong support of this. Thank you.
Thank you very much. Next, we have testimony from the Office of Hawaiian Affairs. In support. Welcome. Please proceed.
Okay. Aloha, Chair, Vice Chair, members of the committee. Kaylee Enixon from the Office of Hawaiian Affairs, and we will stand in strong support. OHA believes this program is essential for addressing mental health challenges and substance abuse issues that disproportionately affect our Native Hawaiian community. Access to mental health care is crucial to divert individuals who wouldn't be involved in the criminal justice system if not for their mental health crisis. The proposed legislation provides an effective solution to redirect people from the criminal justice system to the healthcare system. This collaborative approach encourages a comprehensive and potentially more culturally sensitive response that can be specifically tailored to the unique needs of our Native Hawaiian community. And mahalo for the opportunity to testify.
Mahalo. Next, we have testimony from the Hawaii State Department of Health.
Good afternoon, Chair, members. My name is Courtney Matsu, Deputy Medical Director and Acting Administrator for Adult Mental Health Division. We strongly support this measure. As you know, we recently opened the Behavioral Health Crisis Center. It was well received, and it will fill a critical gap in our crisis continuum. In regards to the mental health emergency workers, we feel that these individuals are the most equipped to make decisions regarding dispositions on people who are in mental health crisis. We did have some proposed amendments to the bill. One would allow the director to have the authority to divert individuals in crisis to a behavioral health crisis center, because currently the statute allows only for hospitals. We also requested an effective date upon approval or passage of the bill. And then finally, the last amendment was in regards to address the safety of first responders. If you have any questions, I'll be here. Thank you.
Thank you very much. Next, we have testimony from the judiciary and in support. And then we have testimony from the State Council on Mental Health in support. And we have testimony from Hawaii Disability Rights Center.
Yes. Thank you. Thank you again, Chair. I'm Lou Erdeshek, Director of the Disability Rights Center. It seems like there's a lot of bills on the subject, as the gentleman said, and there's a lot of details that have to be worked out. My position is simply that in the big picture of things, and certainly at the policy level where you folks are, it clearly makes sense to move towards mental health workers and behavioral crisis centers and away from police and emergency rooms. And so others can definitely give you more advice as to how the language should be crafted, but in the big picture of things, this makes a lot of sense if you're trying to address this problem. Thank you.
Thank you very much. Next, we have testimony with comments from the Community Alliance on Prisons. Next, we have testimony with comments from the Queens Health System. And then testimony with support, testimony in support from the Alzheimer's Association, Hawaii Primary Care Association, Opportunity Youth Action Hawaii, Hawaii Substance Abuse Coalition, Aloha Care, and Hawaii Psychological Association, and testimony with comments from an organization called Reimagining Public Safety in Hawaii Coalition. Is there anyone else wishing to testify on Senate Bill 3139? If not, questions, members? Seeing none, thank you to the testifiers. We'll go on to the next measure. Senate Bill 2305 relating to missing persons. This measure establishes a Silver Alert program within the Department of Law Enforcement to help locate and safeguard missing persons who are 65 years of age or older, cognitively impaired, or developmentally disabled, and it appropriates funds. First up, we have Department of Law Enforcement.
Good afternoon again. The Department of Law Enforcement stands in strong support of this measure by providing a Silver Alert, another vehicle or tool to help us protect the members of our community that currently lack some opportunities for word to get out to be able to help them if they're in need to be found and helped. And we stand in strong support, and I'm here for answer any questions if you have any. Thank you.
Thank you very much. Next, we have testimony and support from the Office of Hawaiian Affairs.
Good afternoon, Chair, Vice Chair, members of the committee. The Office of Hawaiian Affairs stands on its written testimony in support of this matter. We appreciate protection of our kupuna. Mahalo.
Thank you. Next, we have testimony and support from Hawaii State Council on Developmental Disabilities.
Thank you, Chair, committee members. Dane Bartolos, Executive Director for the Hawaii State Council on Developmental Disabilities. We stand in strong support. We want to thank the Alzheimer's Association for collaborating with us on this measure. Individuals with developmental disabilities often have a hidden disability. So just looking, you wouldn't tell that they are lost or confused. And we've had individuals go missing 8, 10 hours just roaming around a neighborhood because someone says, are you okay? Yes, I'm okay. We've had other individuals say, do you need a ride? Okay. And they end up going but not being able to say where to go. So this is very important to us, and thank you for this opportunity to testify and for your support.
Thank you. Next, we have testimony and support from the Executive Office on Aging.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Caroline Kadirao. I'm the Director for the Executive Office on Aging. We're an attached agency to the Department of Health. We stand in strong support of this measure as long as it doesn't defer or deflect any measures in the executive budget. This is a very good bill. Again, it establishes a silver alert program. It will keep our kupuna and individuals with developmental disabilities safe. I just want to take off my director's hat for just a moment. I lost my father who has dementia for about an hour a few years back. Luckily, we found him, but a measure like, or a silver alert program such as this would have helped us to find him even faster. So we stand in strong support of this measure, and I'm here for any questions. Thank you.
Thank you very much. We have testimony and support from the Office of Wellness and Resilience, from the Office of the Governor. We have testimony with comments from the Department of Human Services. Next, we have testimony from the Honolulu Police Department.
Aloha, Chair. Aloha, Vice Chair and Committee. I stand on the submitted testimony to oppose the bill, and I'll summarize everything. Number one, in some states they have like 11 different types of alerts. Now, that may they diminish the effect of our Amber Alert. One thing I want to make a statement that I don't oppose taking care of a kupuna because I'm one of them and I have parents as well. And as I go on, you'll understand. What I fear of, is just like getting alerts from your phone's notifications. It will diminish the effect and people won't look at it anymore if we continue to put more alerts out there. But one thing, the Honolulu Police Department has a missing persons detail that we're there 24/7. We have the organizational structure. We have the police force that takes care of the entire island. And we also work with the other counties as well. And we don't ask for any additional funds to do this. And number three is we do take care of the kupunas. Statistically, since 2020, the HPD has more than 100 cases per year, and with a closure rate of 99%. Approximately 20 individuals who were found deceased before the missing report was made, and only one was found deceased after the report was made. We have successfully, in current efforts, to locate our keiki and kupuna. And that's how and I'm here for any questions.
Thank you very much, sir.
Thank you.
We have testimony and support from the Hawaii County Office of the Prosecuting Attorney. Next, we have testimony and support from the Hawaii Disability Rights Center. Mr. Rishik.
Yes, thank you again, Chair Tornes. When this committee heard a House version of this, I was on Zoom and I related a personal story about friends of mine from Canada whose aunt went wandering off. So I'm not going to bore you by repeating the same story, but there are a couple of things that stand out, and in particular, in light of the position of the Honolulu Police Department that I think need to be made. These were friends who were here for a college graduation. They were here. The aunt wandered off and was missing for over 24 hours. A missing person report was filed with HPD. The police were not unhelpful particularly. They just didn't know where she was, like we didn't. There was a TV announcement. So we did everything that the current system allows you to do. The only reason she was found is that about a day later, she wandered into a beauty salon near Ala Moana and must have looked really weird because she just sat down. And so the operator of the salon called the police. The police came upon the woman. They didn't know that she was on the missing person list. They didn't know she was on TV. They looked into her purse, and there was a note that said, "If I'm lost, call my niece." So they called her niece in Canada, who then called the family here, and that's how the connection was made. So it wasn't made by the current system that the officer was talking about. And so it shows to me that we clearly have gaps in the current way we're doing things. And so a silver alert would have to be an improvement over that situation. So I hope you will give strong support and consideration of that. Thank you.
Thank you very much. Next, we have testimony and support from the Hawaii Primary Care Association.
Hi, Eric Abe for the Hawaii Primary Care Association. We are in strong support of this measure. We have been working closely with the Alzheimer's Association from the outset. As you review the testimony, you'll notice that there is broad and strong support from the entire community on this measure. We understand the concerns raised by the Honolulu Police Department, and we're hoping that under the leadership of the Alzheimer's Association, that we can continue discussions with HPD in the hopes of finding a compromise that would ultimately benefit all of our citizenry. And so to keep the discussions, to continue discussions, at least for the remainder of this session, I humbly ask for your support for this measure. Thank you.
Thank you very much. Next, we have testimony and support from the Alzheimer's Association.
Aloha, Chair Tarnis, Vice Chair Takayama, members of the committee. Ron Shimobuku from the Alzheimer's Association. Really want to extend our mahalo for hearing this measure and that of its companion, House Bill 1774. You have our testimony and strong support, but I would like to emphasize and highly stress that, simply put, this bill will save lives. Data and statistics are important, however, it does not outweigh the lives that are at stake. I urge you to listen to the stories on this bill and take the time to read through the testimony. You will find the current system, again, is just not working, with all due respect to the opposition. You will find that the current system is not working. Kupuna are still missing, and our loved ones are left without any closure. This alone should be reason to move forward on this measure. The Alzheimer's Association is committed to establishing a silver alert program statewide here in Hawaii. Let's not be the lone standing state with no codified process for missing kupuna, especially since we, the people of Hawaii, hang our hats on caring for our keiki and kupuna. Mahalo for the opportunity.
Thank you very much. We've received testimony from numerous organizations and support and individuals, and we've got two more that have said they'd be here to testify. First up is Joseph Burr.
Yes, I'm on Zoom, if you can hear me.
I do hear you. Please proceed.
Okay, thank you for this opportunity. I'd like to address the chair, the vice chairman, and the assembled committee members. My name is Joseph Burr, as stated, and I would like to state that I strongly support Senate Bill 2305. As stated, the bill is under discussion to establish a silver alert system. On a personal note, I became aware of the need for a silver alert system in Hawaii after my brother, a senior citizen resident of Meliani, had been diagnosed with dementia coupled with the residual effects of Agent Orange exposure from his time in Vietnam. On October the 2nd of last year, my brother wandered, as they say, during an episode. And unfortunately, with a limited search by law enforcement and an exhaustive search by family members, his remains were discovered on November the 22nd, 7 weeks after he wandered. It should be noted his remains were discovered less than 10 miles from his home. I firmly believe that had there been a robust silver alert system in place, utilizing law enforcement, electronic and print media, coupled with social media exposure and other available resources, my brother and others in similar situations would have been found safely returned to their family, as opposed to having their remains returned to the family for burial. I have a strong belief that if Hawaii were to develop and implement a robust and functioning silver alert system to help locate these individuals that have dementia, cognitive impairment, or developmentally disabled issues, my brother, for one, would be with us today. It's known that 6 in 10 people with dementia will wander at some point, And with the increasing aged population of Hawaii, the number of residents prone to wandering will only increase in the coming years. In closing, I'd like to say it should be noted that at this time, Hawaii is one of the few states in our nation that does not have a formalized Silver Alert program. And again, I strongly urge support and passage of Senate Bill 2305, as along with the rapid implementation of that program. And I do thank the committee for the opportunity to share my family's story and to support Senate Bill 2305. Thank you.
Thank you, Mr. Burr. Next, we have testimony and support from Ka'ili. Welcome, please proceed.
Good morning, Chair. Good afternoon, Chair, Vice Chair, and committee members. My name is Kylie, and I'm strong support of this bill because state of Hawaii don't have Silver Alert for people with disability or elderly individual went missing. It would be great if Hawaii have Silver Alert in state of Hawaii EAS plan so people can locate the individual and bring them back where they belong safely. Please pass this bill. Thank you, and please let me know if you have any questions.
Thank you, Kylie. Appreciate that. There's numerous individuals and organizations that have testified, sent in written testimony in support, total of 43 in support, and we've heard the testimony from the Honolulu Police Department in opposition, and there was one testimony with comments. Is there anyone else wishing to testify on Senate Bill 2305? If not, questions, members? Someone on Zoom?
Chair.
Oh, yes, please proceed and introduce yourself.
Good afternoon, Chair. I'm Audrey Suga Nakagawa. I'm the Advocacy Director for ARP Hawaii, and we stand in strong support of this measure. It's a system that's long overdue. I do know that we have many mechanisms already in place as shared by the police department, but we can do better. We need to really improve our system. Timeliness is so important in trying to help and find a loved one who is missing. And so we really appreciate that this bill be passed forward. Thank you very much.
Thank you, Ms. Suga Nakagawa. Anyone else wishing to testify on this measure? If not, questions, members? Vice Chair Takayama.
If I could ask the Honolulu Police Department, Captain.
Yes, sir.
Captain,
Yes, sir.
In your testimony, you talked about how some states have 11 different kinds of alerts.
Yes.
Of this, how many does Hawaii have?
Right now, just that Miley alarm.
We just have one.
Yeah, and just to take note, even at those states that have those different types of alerts, they go through one clearinghouse that approves all that and has a standard of sending it out. We're kind of unique in Hawaii because you go to other states, there's different counties. You could just drive like 5 miles and it's a different area code or a different zip code.
I guess we have the advantage of being islands.
Yes,
right?
yes, sir.
So the Miley Alert, the Miley Amber Alert program has been in existence since 2005, you say in your testimony? And since then, how many times has it been activated?
We only activated it twice.
Just twice in almost 20 years?
Yes, and we just did one recently.
So it doesn't sound like we're in too much danger of overusing the system. Anyway.
Yeah, not with the Amber Alert, yes,
Right.
correct.
So in your testimony, you say the investigating agency, such as HPD, should be the one to put out the alert because the information comes in quickly and time is of the essence. So if you do decide to put out an alert for someone other than a keiki, an older person who
Yes, sir.
might be disoriented and such, how would you put it out?
We do pretty much everything except the alert. We go media release, we use the social media. We also use Crime Stoppers that's in our building as well. And we also send out officers too.
So if you already use many of the tools that would be utilized by the proposed Silver Alert, why would you oppose setting up a system such as Silver Alert?
The alert system that goes out like through the tunnels and then through the media, above the freeways and and through, I'm scared of, if we continue to put more alerts out, people will be immune to that, or it won't be as effective. Just like our notifications on our phone, and just like tsunami warnings that we have here and there. We get them so much during our tsunami season that people are still on the beach, and still people don't pay attention to that anymore because it's just too much. The effectiveness of this Amber Alert is because we have a criteria for that, and it's a sole alert. If we keep on adding alerts, I'm just scared that it won't be as effective. I mean, not that what we're doing now is effective, even with our missing persons that include all ages.
Now, you talked about having certain guidelines. I don't know if you've had a chance to examine the bill, but it does specify that there are certain guidelines, protocols that would be used to determine whether a silver alert is warranted,
Right.
such as the person being disappearing under suspicious circumstances, or under disoriented medical conditions, that sort of thing.
Correct.
Is that not criteria that would satisfy your concerns that they would be issued over frequently?
See, how the bill is written, normally, right now, a report would be made, which is normally HPD, through HPD, as they call 911. The bill, then we would pass it on to our criminal investigation division, our missing persons. And then if we add another step, it would slow things down. I don't know if you understand.
I think I understand, but it seems to me that the more eyes and ears you have alerted to a situation where a person is missing, such as an elderly person, they don't wander far, but they do wander.
Yes,
And it seems to me that if you have a system such as the one proposed that can limit the geographic scope of where the alert is issued, it seems to me that might address your concern that everyone is alerted and everyone is maybe desensitized to these alerts.
Yeah, just with the silver alert, but there's also other interests out there that have other alerts as well.
Well, we only have one.
If we continue to go on this route, there's no reason why we won't approve these other alerts as well.
So if I understand what you just said, you're okay with the silver alert, but no more?
I mean, I'm okay in taking care of our kapuna. Yeah. There's nothing wrong with finding, lost elderly people with disabilities, and
Thank you.
What is working now is effective.
Yeah,
That's what I'm
I
saying.
agree, it is working, but
Yes.
the situation is sort of like someone who buys a new car and then takes the bus to work.
Okay.
I mean, you're afraid to use it, and yet it's sitting there as an opportunity to perhaps save lives. So anyway, no more questions. Thank you.
I understand. Thank you.
Thank you very much. Other questions,
Thank you.
members?
Thank you.
Thanks very much to the testifiers. We'll move on to the next measure. Senate Bill 572, Senate Draft 2, House Draft 1, relating to agriculture. This measure authorizes and specifies conditions under which the Department of Agriculture may declare a biosecurity emergency, during which the department and governor may take certain actions to prevent the establishment or spread of pests and prohibited or restricted organisms. It broadens the objectives and general actions of the biosecurity program. First up, we have the Department of Land and Natural Resources.
Aloha, Chair, Vice Chair, members of the committee. My name is Chelsea Arnott on behalf of the Department of Natural Resources and also program support for our Hawaii Invasive Species Council. The department stands on its written testimony and support. This measure just expands the Department of Agriculture's authority to declare emergency by putting it with the governor, and this will just help us better rapidly respond to new pest incursions or emergencies when it comes to invasive species. I did want to note that there is language in there regarding the Hawaii Invasive Species Council being consulting with the Department of Agriculture. It's not clear what the role of the Hawaii Invasive Species Council is in the language that's written, so just looking for some clarity on the council's role in this measure. Mahalo.
Thank you very much. Next, we have testimony from the Hawaii Department of Agriculture.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Jonathan Ho. I'm the acting manager from the Department of Agriculture's Plant Quarantine Branch. Yeah, we're in support of this measure. We appreciate the legislature's inclusion of prior suggestions for this measure. One of the biggest issues with regards to invasive species is the ability to rapidly obtain resources to do that management. The department is quite small. We have less than 0.5% of the state budget, and having the ability to access these resources quickly, utilize them, and then basically give them back and not maintain them is something that we think would be most effective in managing invasive species moving forward. Thank you. I'm available for questions.
Thank you very much. Next, we have testimony in opposition from the Hawaii Harbors Users Group. Next, we have testimony in support from the Hawaii Farm Bureau.
Thank you, Chair, Vice Chair, Representative Miyake. Brian Miyamoto here on behalf of the Hawaii Farm Bureau. We're in support of this measure. We believe it will provide tools to the Department of Agriculture to address our widespread invasive species problem that's affecting not just agriculture, but Hawaii's fragile ecosystem. We understand this measure doesn't include any appropriations, that's not being asked, but we do urge this committee and the legislature to consider other measures such as HB 2619, which does ask for funding for the Hawaii Department of Agriculture's biosecurity program, a comprehensive invasive species program. We want to make sure that the department is properly funded and their partners are also funded so we can address this invasive species problem that is affecting our entire state. Thank you for the opportunity to testify.
Certainly, thank you. We've also received testimony and support from the Maui Chamber of Commerce, Hawaii Floriculture and Nursery Association, and 2 individuals. Is there anyone else wishing to testify on Senate Bill 572? If not, questions, members? Seeing none, we'll move on to the next measure. Senate Bill 3191, relating to technology transfer at the University of Hawaii, permanently authorizes the University of Hawaii to continue to regulate conflicts of interest and other ethical issues for technology transfer activities sponsored by the University of Hawaii. Up first, we have, what do we have up first? University of Hawaii. Thanks for being here, sir.
Good afternoon, Chair, Vice Chair. This is Vasily Sirmus from the University of Hawaii. We are in strong support of this bill. The university is not asking an exemption from the State Ethics Code. We have been managing conflict of interest for tech transfer activities through our Board of Regents. We have Regents policies, executive policies, and administrative procedures to do so for the last 7 years. Thank you.
Thank you, sir. Next, Robert Harris from Hawaii State Ethics Commission. Stepped out. Anyone else wishing to testify on Senate Bill 3191? If not, questions, members? Seeing none, thank you. We'll move on to the last measure on our agenda. Senate Bill 2832, Senate Draft 1, relating to the traffic code. This measure specifies that the counties may issue traffic infractions for violations of any law prohibiting or restricting the stopping, standing, or parking of vehicles on all highways. It authorizes stopping, standing, and parking restrictions and prohibitions on property under jurisdiction of the Director of Transportation and the counties, respectively. On this measure, we have testimony and support from the County of Maui, from the Hawaii County Office of the Prosecuting Attorney, We had from the mayor of the county of Maui, also county council chair of the county of Maui, and also testimony and support from the Ulupono Initiative. Is there anyone else wishing to testify on Senate Bill 2832? If not, questions, members? If not, thank you very much to all the testifiers. We're going to recess briefly until we get quorum so we can go into decision making. Recess. Thank you. We're reconvening the hearing of the Committee on Judiciary and Hawaiian Affairs. It's Wednesday, March 20th, 2 p.m. here in Conference Room 325, and we're reconvening for the purposes of decision making. On the first measure, should I do one member for the House and one for the Senate? Whatever. Okay. Thank you. I was just conferring with the chair of the Water and Land Committee who heard this measure first. So Senate Bill 2836, Senate Draft 2, House Draft 1. I'd like to recommend that we amend this since we are not supposed to have legislative members serving on a board that extends beyond advisory capacity. And that is because of Article 3, Section 8 of the Hawaii State Constitution. And since this board facilitates the acquisition of funding and resources for state and county housing recovery programs, I will need to amend this bill to remove the 4 representatives, 2 from the House and 2 from the Senate. And in its place, what I'm going to do is recommend that the House Speaker name 1 individual and appoint to this board, and that the Senate President appoint 1 individual to this board. In addition, I believe that the reference to subsection A32 should actually be to subsection A33. And this is the paragraph that deals with Maui County Council members, since that paragraph establishes a process for an alternate. In addition, I'd like to make technical amendments as well. So as those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 2836 SD2 HD2. Chair and Vice Chair vote aye. Representative Evslin?
Aye.
Representative Ganadin? Representative Holt excused. Representative Ichiyama? Aye. Representative Iligan?
Aye.
Representative Kong? Aye. Representative Miyake? Aye. Representative Souza excused. Chair, your recommendation is adopted.
Thank you very much. Senate Bill 3157. On this measure, I'd like to move it out with technical amendments only. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 3157 SD2 HD2. All members being present except for Representatives Holt and Souza. Any members voting with reservations or no? Your recommendation is adopted.
Thank you. Moving on, Senate Bill 2475, Senate Draft 2, House Draft 1, relating to education. On this measure, I'd like to adopt the Attorney General's amendments. Also, the Department of Human Services amendments. And also, I'd like to adopt the Hawaii Teacher Standards Board amendment on page 9, line 1 to 3, adding the word public or private before the word educational institutions, and then make technical amendments. And also, I would like to make it clear that private schools, public charter schools, and early learning programs are also required before transmitting an employee's name and other information for inclusion on the registry, that they certify that the employee either has waived the right to appeal or has lost the appeal. I want to make sure that that's clear in here. And we'll also make some technical amendments. Those are my recommendations for amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 2475 SD2 HD2. Any members with reservations or noes? Recommendations adopted.
Thank you. Next bill, Senate Bill 2351, Senate Draft 2, House Draft 1. We heard the companion measure to this bill, and I think we did a good job on it, so I would like to insert the contents of House Bill 2199, House Draft 2, into this bill and make some additional technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2351 SD2 HD2. Any reservations? Noes? Reservations for Representative Ganadin. Chair, your recommendations adopted.
Thank you. Senate Bill 578, Senate Draft 3, House Draft 1. I would like to move this out as is. I did, just so everyone knows, I did ask the Labor Chair to include Department of Agriculture, and he declined to give me prior concurrence, so I'm not able to do that. And nor was he in agreement to add Department of Law Enforcement, so I asked. So I think we can need, the only thing we can do is move it out as is, which I think we should do to help the Attorney General. So that's my recommendation, as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 578 SD3 HD1, passing as is. Any reservations or noes? Recommendations adopted.
Thank you. Next measure. Senate Bill 2556, Senate Draft 2, House Draft 1, relating to the Community Outreach Court. On this measure, we're just going to make technical amendments. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2556 SD2 HD2. Any reservations or noes? Recommendations adopted.
Thank you. Senate Bill 2557, Senate Draft 1, relating to legal representation. I'd like to move this out with technical amendments only. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2557 SD1 as amended. Any reservations or noes? Reservations for Representative Ganadin. Chair, your recommendations adopted.
Thank you. Senate Bill 2685, Senate Draft 1, relating to abusive litigation. I'd like to adopt the judiciary amendments and also make some additional amendments, which I'll describe now. Page 7, line 1. The words, quote, being filed, initiated, advanced, or continued primarily for the purpose of should be inserted before the word harassing for consistency with page 6, line 1 to 4. Then on page 8, line 19, and on page 10, line 2, I want to make the reference, instead of being to domestic violence, it would be to intimate partner violence. Page 9, line 5 to 8. Oh, sorry. And then the last amendment is, since the deadline for the judiciary to create forms and train judges is not until January and July 2025, I'd like to insert a delayed effective date for Section 2 of the bill to coincide. And then we'll make technical amendments as well. Those are my recommendations for Senate Bill 2685 SD1 with amendments. Questions or concerns, members? Representative Ganadin.
Thank you, Chair. I suppose I'm going to be voting with reservations. I don't like what this bill implies. It implies that family court judges can't read the record and that they won't just deny frivolous or unnecessary motions, which they do every day. Also, the standard best interest of the child for custody cases is really open here in the state of Hawaii. So it affords appellants the opportunity to, or litigants the opportunity to come back into court, which they do, and they should. So real concerns about this. I think the underlying concern for me is about continuing counsel for victims of domestic violence after a divorce and custody case has been settled. Litigants have to come back to court, and I think it's going to be the government and nonprofits' job to make sure that those individuals continue to have good counsel. I'm not sure if this is the answer.
Understood. Thank you. I appreciate your perspective on that based on your extensive experience. Other comments or concerns? If not, Vice Chair for the vote.
Voting on SB 2685 SD1 with amendments, noting the reservations of Representative Ganadin. Any other members of those reservations or noes? Recommendations adopted.
Thank you. Senate Bill 2319, proposing an amendment to Article 6, Section 3 of the Hawaii State Constitution to increase the mandatory retirement age for state justices and judges. I'd like to move this out as is. Questions or concerns, members? Yes, Representative Ganadin.
As myself and Representative Souza voted no on the House version just a month ago, I'm going to be voting no again. I'll stand with the voters of 2006 and then with this body in 2014 that declined to change the Constitution. Understandably, many brilliant judges have been forced into retirement, but we get them back. They serve honorably in this community as mentors, as advocates, and on a variety of different boards throughout the state. And I think it would be a disservice to the rest of the community to keep them in the bench. I'm going to be voting no.
Understood. Thank you. Any other comments or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2319, passing as is, noting the no vote of Representative Ganadin. Any other reservations or noes? Recommendations adopted.
Thank you. Senate Bill 3139, Senate Draft 2, House Draft 1. On this measure, I'd like to recommend making some amendments. On page 16, line 3 to 4, I think the intention is to make the crisis intervention coordinators permanently exempt from Chapter 76, the civil service laws, so we'll need to make an amendment to make that clear. I'd like to adopt the Department of Health's amendments and the amendments from the Hawaii Substance Abuse Coalition in their testimony, and then also make technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3139, SD2, HD2. Any reservations or noes? Recommendations adopted.
Thank you. Senate Bill 2305, Senate Draft 2, House Draft 1, relating to missing persons. On this measure, I would like to make a couple amendments. One of them is to use the definition for the individual who would qualify for this to track the same language we used in House Bill 1774, House Draft 2 from earlier this session. So we'll modify it slightly to use the same definition we had in our bill, HB 1774 HD2. In addition, we will make some technical amendments. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2305, SD2, HD2. Any reservations or noes? Recommendations adopted.
Thank you. Next measure, Senate Bill 572, Senate Draft 2, House Draft 1, relating to agriculture. On this measure, I'd like to make a couple some amendments. Page 3, line 10 to 11, where it says 100 days, let's say, make it clear, and it should say 100 calendar days. On page 6, lines 16 to 17, I think we can delete the words "or out of the general revenues of the county as appropriated." And the reason why I want to delete those words is because this bill really deals with actions by the state. In addition, I'd like to make some technical amendments for clarity, consistency, and style. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 572, SD2, HD2. Any reservations or noes? Recommendations adopted.
Thank you. Senate Bill 3191, Senate Draft 1, House Draft 1, relating to technology transfer at the University of Hawaii. I'd like to move this out with technical amendments only. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3191, SD1, HD2. Any reservations or noes? Recommendations adopted.
Thank you. Final bill, Senate Bill 2832, Senate Draft 1, relating to the traffic code. I'd like to move this bill out with technical amendments only. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2832, SD1, HD1. Any reservations or noes? Recommendations adopted.
Thank you. There being no further business before this committee, we are adjourned.